Hello and welcome to another episode of Surviving Constitutional Law. I'm your host, Cameron Shamsabad. In today's episode, we're going to be continuing our study of Australian legislative powers, and today we're going to be starting on some of the substantive powers that are set out in Section 51 of our Constitution. In particular, we're going to be discussing the trade and commerce power, which has a very broad application in Australia and quite an interesting history, as we're going to detail in this episode. So today we're going to be diving into the topic which is based on Section 51, subsection 1 of the Constitution, and also we're going to be discussing some of the provisions which are relevant to its exercise. To do this, we're going to go through a very basic structure. The first thing is I'm going to discuss some of the history of the trade and commerce power, as well as, after that, the nature of the power and its scope. Following from that, I'm also going to talk about the limitation within the power that it is limited to interstate trade as well as foreign trade. And I'm also going to set out some of the incidental aspects of the power as well as express limits found in Section 92 of the Constitution. A main focus of today's episode will be differentiating, of course, between interstate trade, being those commercial activities which cross state borders, and of course intra-state trade, which are activities which solely occur within the one state jurisdiction. So, I hope you are comfortable and that you will sit back, relax, and together we can start the topic. So, getting started on the history of the trade and commerce power, let's firstly set out what the basis of authority is for the Federal Parliament to legislate on the subject matter. To do so, we have to look to Section 51 of the Commonwealth Constitution, which states, quote, "The Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth with respect to, subsection 1, trade and commerce with other countries and among the states." End quote. The powers enumerated in Section 51 by the reference to peace, order and good government are generally deemed to be broad and plenary in nature, unless a limitation is expressly stated in the Constitution. As you will recall back to our second episode, the words in relation to state constitutions are deemed under English law to be giving them a very broad basis of power and are not, in fact, used as words of limitation. Aside, of course, from express limitations within our Constitution that might be found in other sections outside of Section 51, there are alternatively, within these heads of power that are in Section 51, certain implied limitations which the High Court has discovered through interpretation of the Constitution. Indeed, Quick and Garron, in their seminal constitutional text, state at page 362, quote, "Thus the grant of power over trade and commerce in Section 51(1) is subject to further qualifications and restrictions contained in subsequent sections." End quote. Quick and Garron, of course, being two of our framers who are at the late conventions of the 1890s. Now, this power was developed by our framers with the benefit of hindsight, of course, from the UK, US and Canadian common law systems, which our framers studied quite rigorously in drafting the sections of our Constitution which we now have. In particular, the trade and commerce power, one can trace back to the Commerce Clause of the US Constitution, as well as certain provisions of the Canadian Constitution, or British North America Act, as it's more correctly known. The roots of Section 51(1) can be found particularly in the American Constitution, which relevantly states at Article 1, Section 8, subsection 3, that the Congress is endowed with the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes, end quote. Analogously, the British North America Act of 1867, which forms a major core of the Canadian Constitution, under Section 91, subsection 2, grants their Parliament a power, quote, for the regulation of trade and commerce, end quote. The major difference between these predecessors and our own Constitution is that Section 51 does not make mention to regulation of trade and commerce. It gives a far more broad scope to the provision in itself. For this reason, Quick-and-Garron concluded that, quote, the omission of the words the regulation of can certainly not be held to narrow the scope of the power, and may perhaps in some degree extend it, end quote. In the absence of any further limitations, therefore, some of which we will come to later in the episode, this head of power is considered quite wide in its potential application. But that leaves us with the question, why did our framers add this clause to our Constitution? Well, the answer, as with many of our constitutional ideas, is derived quite closely from the American system of government and also the problems which our colonial governments were facing and could be closely related to the problems that some of the newly formed state governments were facing after the American Revolution. Now, the importance of the American Commerce Clause, as it is known, was summarized in the case of Gonzalez and Raich, found at U.S. Report 545, starting at page 1 in the year 2005, where the court stated, quote, the Commerce Clause emerged as the framers' response to the central problem giving rise to the Constitution itself, the absence of any federal commerce power under the Articles of Confederation. For the first century of our history, the primary use of the clause was to preclude the kind of discriminatory state legislation that had once been permissible, end quote. Prior to the passage of the American Constitution, the new state governments began enacting legislation which unfairly regulated trade or imposed taxes on goods that were imported from their neighbouring states. This caused friction and disputes between the former colonies. As such, the drafting conventions of the 1787 period determined that the new National Congress would be granted the power to regulate interstate foreign trade, thereby preventing state governments from imposing any prejudicial domestic trade policies or making foreign trade deals to the detriment of their neighbouring states. Quite similarly, the Australian framers sought to ensure that the trade and movement between the various state jurisdictions would be uniform and fair. For analogous reasoning, therefore, our framers gave the power over interstate trade and commerce to the Commonwealth in the same way that the American state governments abdicated that power in favour of their newly formed federal government. The decisions of the US Supreme Court, as is evidenced by the extensive references made by Quick-and-Garron in their book, as well as Andrew Inglis Clark in his book, served our framers in defining the meaning of trade and commerce within our own Constitution. One such example of an American case which had such an influence was the case of Gibbons and Ogden, which can be found at the 22nd US Report, 9 Wheat, at page 1 in the year 1824, which was a landmark judgment handed down by the august Chief Justice John Marshall. This case, broadly speaking, set out the powers of the US Congress to regulate navigation and movement among other activities within the United States, so long as such could be, quote, in any manner connected with commerce with foreign nations or among the several states, end quote. As such, this case gave a broad definition to commerce as including all commercial traffic and intercourse. For a century following this decision, a great deal of jurisprudence was developed which focused primarily on the validity of state legislation which might in some way regulate interstate trade. Nonetheless, the Commerce Clause in the US is arguably the most broadly interpreted power of Congress, and predictably, circumstances are quite similar in Australia, with the exception, of course, for the external affairs or the aliens power or even the corporations power. The Australian High Court has given Section 51, subsection 1, a rather wide reading from its very earliest decisions. An early example of this is the High Court case of W&A MacArthur Limited and Queensland 1920, which can be found at volume 28 of the Commonwealth Law Report, starting at page 530. Particularly at page 546 and 47, the court found that the provision of trade and commerce in the Constitution broadly means, quote, trade and commerce between different countries. We leave out for the present the word intercourse. Has never been confined to the mere act of transportation of merchandise over the frontier. That the words include that act is, of course, a truism, but that they go far beyond it is in fact quite undoubted. All the commercial arrangements of which transportation is the direct and necessary result form part of trade and commerce. The mutual comings, the negotiations, verbal and by correspondence, the bargain, the transport, and the delivery are all, but not exclusively, part of the class of relations between mankind which the world calls trade and commerce. End quote. This very broad definition was, however, much like its US predecessor, distinguished as being limited to interstate and foreign commercial activities. In Canada, their equivalent provision found in section 91 subsection 2 of their constitution was initially limited in its application as applying only to foreign and interstate trade, as well as the general regulation of trade that could affect the whole dominion or nation. Trade solely within a province, according to the case of Citizens Insurance Co. of Canada and Parsons, 1881, was left to the provincial governments, which are very similar in a lot of ways to our state jurisdictions. The Canadian approach was altered, however, in the 1978 Canadian Supreme Court opinion of reference RE Agriculture Products Marketing, whereby the court determined that the general regulatory power exception set out in Parsons could be utilised to include even producers who did not export their products across provincial lines, or, as we would say in Australia, state lines. The decision also determined that through cooperative federalism, the provincial government could impose their own regulations of interdomestic trade so long as it conformed to the federal standards. As such, the Canadian constitutional developments throughout the 20th century in relation to trade and commerce has been quite unique from either the American or our Australian equivalent. It is very likely that this can be explained, of course, by the Canadian approach to federalism being structurally in the reverse to either Australian or US federalism, in the sense that Canadian federalism has as its residuary of power in cases where there is a blind spot, the federal government presumptively having the final authority, whereas the state governments or provincial governments in Canada have defined and enumerated powers, which means their system is slightly inverted to ours, I guess you would say. Now, in Australia, the general commercial relationship between citizens was described by one of our most prominent framers, Andrew Inglis Clark, who stated in his book Studies in Australian Constitutional Law, quote, "Under the Constitution of the Commonwealth, all the residents of the several states of the Commonwealth are politically one people with respect to all commercial intercourse among themselves and with other countries, and that any exercise of governmental power by a state which disturbs the commercial unity established by the Constitution among the residents of the several states is invalid." Now, Andrew Inglis Clark's view as to the commercial relationship between the Australian citizenry over state lines and with each other, regardless of where they're located, is obviously quite important to note, especially given the way the jurisprudence has developed in Australia. And I'd like you to keep that quote in mind as we get towards the end of the episode today. Now, with that said, Clark was also very weary of the Commonwealth, aside from the states, abusing its presumptive supremacy founded in section 109 to invade matters which were solely occurring within a state's borders. In such cases, referring to US case law, Clark opined that it was the High Court's job to ensure compliance with the Constitution by both the Parliament and state governments. Now, having set out this historical context and some of the points of comparison internationally for our topic today, I will move on to how our High Court has indeed interpreted the scope of Section 51, subsection 1 of our Constitution, and also some of the legal developments which have occurred in Australia since Federation. Now, the High Court has given a number of judgments which set out the scope and extent of the Commonwealth's power in relation to trade and commerce. The first major case, as previously quoted, was that of MacArthur, which broadly defined Parliament's powers as being capable of touching all aspects of interstate and foreign trade. In the case of RE Maritime Union ex parte CSL Pacific in the year 2003, which can be found at Commonwealth Law Report Volume 214, starting at page 397, the Court found at page 413 that it is well settled that the exercise of the power Parliament can validly regulate the conduct of persons employed in those activities which form part of trade and commerce with other countries as well as among the states, which means that not only can the government regulate aspects of trade and commerce, the movement of goods, how goods are sold, things like that, but they can also regulate aspects of the labour involved with that process as well. Now, the scope of the power extends further than just mere regulation, as the High Court also held that the Commonwealth may itself engage in trade and commerce under this head of power. Now, this means that under Section 51(1), the Parliament can authorise the creation of government-owned and run businesses. And I'm sure, just if you're an Australian resident, you can probably think of a few businesses which historically were either owned by the government completely and have been privatised, or to which the government still has a major stake. But one such example of this was the case of the Australian National Airways Proprietary Limited and the Commonwealth, 1945, found at Commonwealth Law Report Volume 71, starting at page 29. Now, this case is known as the ANA case. The details are that in mid-1945, Labor Prime Minister Ben Chifley introduced a bill into the House of Representatives that would have the effect of nationalising interstate airlines in Australia and create what would have been a public monopoly on air travel domestically between the states and territories. One affected airline was the ANA, which argued that the law breached Section 51(1) and Section 92 of the Constitution. The Court found ultimately that the law didn't breach Section 51(1), as the government could engage itself in trade and commerce if it so wished. Justice Dixon stated at page 81, quote, "A law authorising the government to conduct a transport service for interstate trade, whether as a monopoly or not, appears to me to answer the description. A law with respect to trade and commerce and among the states. It is only by importing a limitation into the descriptive words of the power that such a law can be excluded." End quote. As such, the Court determined in the ANA case that the government could itself engage in, as well as regulate interstate commerce. However, it could not create a monopoly in doing so that would violate Section 92. This brings us naturally to some of the main limits on the trade and commerce power. Now, the most prominent limit the Court has discussed over the past century is the implied limitation that the Commonwealth may not regulate intra-state trade and commerce. The need for a strict observance of the division between interstate and foreign trade with intrastate trade, which is obviously that which exists purely within New South Wales or Victoria, for example, not crossing any state borders, was set out in the early case of Regina and Burgess ex parte Henry, 1936, found at volume 55 of the Commonwealth Law Report, starting at page 608. The case concerned the validity of Section 4 of the Air Navigation Act 1920, which was created by the Commonwealth. The action arose when, in 1920, each state government had agreed to refer to the Commonwealth the power to regulate airlines so as to create a uniform national standard of aviation. However, only Tasmania had passed legislation under Section 51, subsection 37 to do so of the Constitution, and as such, the Commonwealth was left to justify its regulation of purely intrastate air travel on other constitutional grounds. Counsel for the Commonwealth argued that in order to have effective control over interstate travel, the power in Section 51(1) necessarily included a small measure of power over intra-state travel, which justified the federal regulations of aviation nationally, even where the planes were flying solely within one state jurisdiction. Now, this argument failed to convince the court. The High Court instead found that while the regulations could be applied to territories under Section 122 of the Constitution, it was too general in its application to states, and therefore unconstitutionally regulated intrastate trade. Now, this distinction has often come under academic and political criticism, as quite often it is difficult to separate the two forms of trade. An example presented in Burgess was that planes flying both interstate and intrastate were stopping and commingling at the same airport terminals and hangars, making jurisdiction extremely difficult to manage at times. Even with this in mind, Justice Gibbs, as he then was, remarked in the later case of Attorney General of WA and the Australian National Airlines Commission in the year 1976, found at volume 138 of the Commonwealth Law Reports at page 492 beginning, with his quote at page 502, that the distinction, quote, must be maintained however much interdependence may now exist between the two divisions of trade and however artificial the distinction may be thought to be, end quote. Given the court has repeatedly toed the line in relation to keeping the distinction drawn, many then begun to argue that the Commonwealth's power in Section 51(1) could be extended to allow for regulations of certain intrastate matters, so long as they were incidental to effectuating the Commonwealth's justly made law under the power, as it is allowed through the incidental power set out in Section 51(39) of the Constitution to create laws which are in corollary to another head of power. However, the court has found that the distinction couldn't be overcome by the incidental power in Section 51(39), and in the case of Ragg and New South Wales 1953, found at volume 88 of the Commonwealth Law Reports, with the quote starting at page 385, Chief Justice Dixon stated, quote, "Even in the application of this principle to the grant of legislative power made by Section 51(1), the distinction which the Constitution makes between the two branches of trade and commerce must be maintained. Its existence makes impossible any operation of the incidental power which would obliterate the distinction." End quote. However, the issue again arose in the case of Airlines of New South Wales Proprietary Limited and New South Wales, which is referred to as the first airlines case, in the year 1965, which can be found at volume 113 of the Commonwealth Law Reports. In this case, the court concluded that the relevant New South Wales laws which regulated air navigation were not inconsistent with the Commonwealth regulations under Section 109 of the Constitution, as the latter were expressed as not applying to solely intrastate flights. Unsatisfied with this answer by the courts, both governments then sought to change their regulations. As such, the second airlines case occurred, which was in the year 1965, at volume 113 of the Commonwealth Law Report, starting at page 54. The court ultimately, again here, held that there was no inconsistency to give rise to the question of invalidity regarding the state laws. However, on this occasion, the court did find that the Commonwealth regulations in relation to air navigation generally were this time valid. Justice Kitto expounded on the issue at page 115, firstly stating, quote, "The Australian Union is one of dual federalism, and until the Parliament and the people see fit to change it, a true federation must remain," end quote. However, His Honour went on to clarify that the federal power may interfere with state trade in certain circumstances where there is a strong interrelation between the two forms of trade. And the lack of uniform regulation creates a risk of danger to interstate trade and commerce. In this case, His Honour found, with Justice Windier agreeing, that the danger involved with air navigation posed a risk to interstate trade, and as such, certain Commonwealth regulations of intra-state air navigation were valid and binding so far as they affected intrastate matters that could potentially have an effect on interstate air navigation. Now, another case where the incidental power was introduced to blur the distinction was the earlier case of O'Sullivan and Noarlunga Meat Limited in the year 1954 at volume 92 of the Commonwealth Law Reports, starting at page 565. In this matter, the meat company was charged in South Australia with contravening state laws which prohibited the butchering of animals for commercial export without a licence granted by the State Minister of Agriculture. However, the defendant company was, at the time, registered under federal law to export its meats interstate, and therefore argued that the state law was inconsistent under Section 109. The court found that the laws were, in fact, inconsistent. Justice Fulliger, with whom Chief Justice Dixon and Justice Kiddo concurred, stated that the Commonwealth may control any steps leading to the export itself, generally regarded as the production of a product, which could affect beneficially or adversely Australia's export trade. They found includes the creation of provisions to control the quality of meat being exported and related regulations of packaging and handling. Justice Fulliger stated, quote, "It is undeniable that the power with respect to trade and commerce with other countries includes a power to make provision for the condition and quality of meat or any other commodity to be exported," end quote. Therefore, the Federal Parliament would prevail in regulating any manner which could affect foreign trade by utilising the incidental power in Section 51(39). This case was distinguished on the grounds that, unlike the later airlines case, which concerned the inter- and intra-state trade distinction, in this matter the federal regulations were justified as being incidental to foreign trade and commerce, and thereby avoided the distinction in some measure. Now, the domestic trade distinction, however, was not so easy to conclude. In Attorney General of WA and the National Airlines Commission case, the blurred and somewhat artificial distinction, as described by Chief Justice Gibbs, once again arose in relation to air navigation. In this case, the ANA Commission was authorised under Commonwealth law to conduct passenger and commercial transport flights between the states and territories of Australia. This would mean a plane would take off in Perth and land in Adelaide, for example. However, in 1973, the Commission's powers were extended to allow it to make stopovers within the same state before proceeding to its final destination. As such, the ANA began chartering flights from Perth to Darwin, stopping at Port Hedland, which is in the Pilbara region of WA. The stopover was to make the flight path economically viable. However, an action was brought to the court seeking a declaration that the 1973 amendments were ultimately unconstitutional, as the stopover resulted in the Commonwealth engaging in purely intra-state commerce within WA. Now, the challenge ultimately failed, but the resulting judgment was quite complex. On the technicality that the flight was organised and heading into Darwin, which is part of the Northern Territory, the majority of the court, including Justice Stephen, Murphy and Mason, held that the act was valid insofar as that it relied on Section 122, which is the Territory's power. However, Justice Stephen did also agree with Justice Gibbs and Chief Justice Barwick that it was invalid insofar that it relied on the trade and commerce power. While Justice Murphy dissented on this latter point, arguing for a broader view of Section 51, Justice Mason, as he then was, held that since the Act was valid under Section 122, no consideration of Section 51, subsection 1 was even needed, and therefore the Act was able to stand. Now, this complex judgment led to an unusual situation. 3 of the 5 judges determined that the Act was valid under Section 122, though the same margin determined that it was invalid under Section 51, subsection 1. The latter, of course, is much more relevant to us today. Justice Stephen, in his pivotal judgment, which obviously sat on the fence of both, found in relation to trade and commerce that, quote, "It is apparent that the permitted exercise of the power conferred extends beyond the ambit of that legislative incidental power which Section 51(1) carries with it. It follows that the validity of Section 19b of the legislative section in question cannot gain any support by reliance upon Section 51(1), nor can the resultant deficiency of power be wholly made good by recourse to Section 122. Those deficiencies do not lie only in areas related to Commonwealth territories, where alone Section 122 can be called in aid." End quote. For clarity, in relation to Section 122, His Honour took the view that the power to legislate for the territories was indeed plenary, and didn't require the aid of the incidental power in Section 51(39). This could be contrasted with an earlier judgment of Chief Justice Dixon in the case of Lambshed and Lake in the year 1958, found at the 99th volume of the Commonwealth Law Report, starting at page 132. Where the territory's power is not plenary, or whether the territory's power is, of course, plenary or not, remains undetermined to this very day, and there has been some disagreement, particularly between the views of Justice Stephen and Chief Justice Dixon on this issue. It is, if you are interested, a topic which you could definitely explore in an academic sense. Now, on the question of trade and commerce, Justice Murphy in this A&A case dissented from his colleagues, finding that the power was much wider than the previous judges had initially thought. His Honour Justice Murphy stated in his judgment at paragraph 11, quote, "Section 51(1) and 92 of the Constitution make a distinction between trade and commerce among the states and that which is not, but do not make trade and commerce among the states and intrastate trade and commerce mutually exclusive. The Constitution does not mention intrastate trade and commerce and contains nothing which suggests a rigid separation between the two." End quote. Now, this suggests, in Murphy's view, that the distinction between the two types of trade is far less a constitutional principle and far more a judicially imposed limit which has been created. He goes on to state that keeping the distinction and, quote, "further insistence that even the use of the incidental power in Section 51(39) cannot obliterate the division, keeps the pre-engineer's ghost walking," end quote. As such, he implied that the court was minimizing the trade and commerce power and inhibiting its use by government by taking this approach. His Honour concluded, therefore, that the solution was simple, finding at paragraph 12, quote, "The Commonwealth may override the suggested dividing line, for the words 'with respect to' in Section 51 and the incidental aspect which is attached to each head of power authorise laws dealing not only with trade and commerce among the states, but with intrastate trade and commerce, and with acts or transactions which are not trade and commerce, as long as these are with respect to, that is relevant to, trade and commerce among the states." End quote. This position wasn't accepted by his colleagues at the time, and hasn't been embraced by future courts either. In practice, it would very likely produce in Section 51(1) another expanding source of power by the Commonwealth, which would be in a very similar vein to the external affairs power in Section 51(29), or indeed the corporations power in Section 51(20). Now, more recently, the trade and commerce power was considered as part of as a part issue, within the case of Pape and Commissioner of Taxation, 2009, found at the 238th Commonwealth Law Report, starting at page 1. Which is a case which we refer to quite a number of times in this area of law. This case was brought to the courts after Prime Minister Kevin Rudd's government passed the Tax Bonus for Working Australians Act, number 2, in the year 2009, which during the financial crisis of 2008 and 2009, gave a one-off payment to taxpayers who earn less than $100,000 a year. It was justified primarily as a form of stimulus during an economic crisis, and found justification under the nationhood power within the court, which we will of course come to in a later episode. However, another argument which was mounted by the Commissioner of Taxation was that the law was valid under Section 51, subsection 1 as well, as the payments were for the maintenance of the economy and would have been beneficial to interstate commerce as well as foreign trade. Now, this argument did not sit well, and indeed was rejected by Justices Hayden, as well as Justice Kiefel, as she then was. Justice Hayden in particular found, starting at page 150, that the power, quote, does not permit an argument that trade and commerce in Australia is one indivisible whole, nor does it permit an argument that any legislation having an effect on trade and commerce in Australia must inevitably have an effect on trade and commerce with other countries and among the states. Even if it is assumed that the spending of the bonus payments will have some eventual connection with trade and commerce, it has not been demonstrated that the connection is more than insubstantial, tenuous, or distant. Hence, the legislation cannot be described as being made with respect to trade and commerce, end quote. Justices Hayne and Kiefel likewise found that in neither legal or practical effect was the impugned law one with respect to interstate or foreign trade and commerce. While these three judges were of course in the minority of the Pape decision, dissenting on the main question, their judgment in relation to the trade and commerce power can be relied upon, as none of the majority did in fact consider the issue in their judgment in any substantial manner. This of course leaves us with the conclusion that the federal government may of course regulate interstate and foreign trade and commerce, though is still limited insofar as the court has maintained the distinction between interstate and intrastate trade and commerce as being an implied limitation within the Constitution. Now, another textual limit which is found in the Constitution which has affected the way government utilises the trade and commerce power is the limitation set out in Section 92 of the Constitution, which relevantly states in its first clause, quote, on the imposition of uniform duties of customs, trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free, end quote. Going back to federation, this provision was thought to carry a clear public meaning to express the intention of the framers. Now, Quick and Garron state that the words trade and commerce and intercourse shall be absolutely free are intended, quote, to provide for the perfect freedom of trade and commerce among the states from the moment of the imposition of uniform duties. In order to secure that object, the strongest possible words have been used. Nothing has been left to implication, end quote. The provision was initially proposed by Sir Henry Parkes in the 1891 Convention, with the purpose that it would create freedom of movement and commerce for all Australians on the continent, without prejudice or control by governments. The High Court, however, has not entirely accepted the approach of the framers in relation to this provision, and I will warn you that the jurisprudence in relation to this head of power or this particular provision of the Constitution is deemed extremely complex, and so I shall endeavour to make my summary as digestible to my listeners as possible. So Justice Isaacs in the case of Duncan in Queensland in the year 1916 at the 22nd Commonwealth Law Reports, starting at page 556, found that while a state may regulate its purely internal trade, it was not capable of prohibiting the flow of commerce from other states, purely because it was interstate in its origin. This would of course violate Section 92 in his opinion. Now, this means that the state governments had Section 92 applied to them from a very early point within our federal history. Now, the opinion was supported by the later judgment of Justice Evatt in Regina and Vizard ex parte Hill, in the year 1933, which can be found at volume 50 of the Commonwealth Law Report, starting at page 30, where His Honour gave a very broad meaning to the words "among the states," finding, quote, "The section, if read as a whole, postulates the free flow of goods interstate, so that goods produced in any state may be freely marketed in every other state, and so that nothing can be lawfully done to obstruct or prevent such marketing. The declaration of Section 92 covers goods which are consigned to the markets, as well as goods which have already been sold and are in the course of delivery. In this sense, the consignment and delivery, being part of commercial intercourse, cannot be prevented or obstructed by state legislation." End quote. Arguably, the range of potential matters covered by Section 51(1) are also covered by the Section 92 guarantee of freedom for interstate trade and commerce. While the provision was deemed to have a wide nature in the view of early jurists, it has, however, in more recent times, been the subject of much scrutiny and change, as will be explained. Now, during the Griffith Court days, the case of Fox and Robbins was decided in the year 1909, which can be found at volume 8 of the Commonwealth Law Reports, starting at page 115. And that case found that Section 92 prevented a state government from levying prejudicial taxes against imported alcohol from other states. The court found that while imported goods could be taxed generally with all other items, they could not be singled out based on their state of origin. This, of course, finding that Section 92 could injunct a state government's actions where they were discriminatory. The Privy Council subsequently found that a very similar rule applied to the Commonwealth as well, in the case of James and Commonwealth 1936, and affirmed the High Court's previous ruling that, quote, "Section 92 lays down a general rule of economic freedom and necessarily binds all parties and authorities within the Commonwealth, including the Commonwealth itself, because, as was pointed out by the Privy Council itself, it establishes a system based on the absolute freedom of trade among the states." End quote. The provision was, however, later read down in the bank nationalisation case in 1948, which can be found at volume 76 of the Commonwealth Law Reports. This case found that the freedom of trade was absolute. However, the provision could not be invoked in cases where interstate trade, commerce or intercourse wasn't directly being burdened. Alternatively, it was also found in this case that the provision was subject to an exception for permissible burdens or reasonable regulations. An example of permissible burdens which the court allowed over the course of time included, for example, in the wheat case in 1915, found at volume 20 of the Commonwealth Law Reports, where the court found that the New South Wales government's compulsory acquisition of entire wheat crops in the years 1914 and 15 were completely legitimate. And a similar finding was rendered in relation to milk in the case of Milk Board of New South Wales and Metropolitan Cream Proprietary Limited in the year 1939 at volume 62 of the Commonwealth Law Reports. Now, an example of reasonable regulation, for example, was found in the previously mentioned ANA Commission case in the year 1976, where the court found that certain regulations of airlines for safety reasons were okay, because they potentially, if they were left unregulated or unorganised, posed a risk to interstate trade and commerce. Now, until the late 1980s, an individual rights approach had survived in relation to Section 92 as a protection of interstate trade and freedom of movement. This was supplanted by a free trade approach in the case of Cole and Whitfield in the year 1988, found at volume 165 of the Commonwealth Law Report, starting at page 360. Now, this case found that there was a distinction between free trade and free intercourse between the states. The court also unanimously found in this case that the provision was intended to create a free trade area throughout Australia and deny to Commonwealth and states alike a power to prevent or obstruct the free movement of goods, people or communications across state boundaries. However, the court substantially did read down free trade as meaning the opposite of protectionism, which is the legal preservation of domestic industries against foreign competition. This, of course, is what we would now refer to as the modern approach to Section 92, which means that the provision cannot be invoked unless a state or Commonwealth law clearly advantages one type of intrastate trade or discriminates against certain types of interstate trade in a protectionist fashion. The provision has since been read down in its application to allow for actions which manifestly would be seemingly to contradict its original meaning. For example, in the Barley Marketing Board of New South Wales against Norman case in 1990, which can be found at volume 171 of the Commonwealth Law Reports, starting at page 182. The court unanimously found in that case that a New South Wales authority could compulsorily acquire all barley grown in the state from farmers and void any private market sales in doing so, as the grain had not entered into state trade as yet. Now, the court ignored in this case that the law directly prevented even the possibility of such trade occurring because it monopolised all the barley. The court based its decision on the fact that the law did not discriminate based upon a state or the state of origin of the good. A person from New South Wales, in the court's reasoning, or from outside the state who wished to buy barley would purchase it from the marketing board, and thus there was no discrimination between the two. A buyer in New South Wales had no competitive advantage to a buyer from Victoria, as they had equal access to the government monopoly in both states. Further cases have produced legal tests to be applied to determine whether such protectionist discrimination is present. However, there are good grounds to argue that the court has taken a hose to this provision, such that Section 92 no longer really carries a meaningful application as it once did in today's times. Similarly, freedom of intercourse, or movement, has been subjected to a number of proportionality tests now as well, making its freedom aspect conditional rather than absolute. As is observable from the present border closures during the COVID-19 pandemic, the state governments are now emboldened to close borders on the basis that they believe the policy is a proportional restriction of the Section 92 freedom of movement. So returning to our main topic today, the trade and commerce power. It should be noted that the power is broadly subject to limitations set out in Section 92. However, these Section 92 limits can now only be invoked in relation to trade and commerce when a law is passed that is discriminatory against interstate commerce and is also, in its actions, protectionist towards intrastate business interests. However, even this might be permissible where the court determines the discrimination is perhaps proportionate to achieving a reasonable public policy purpose. With this limit watered down and the distinction between interstate and intrastate commerce being gradually eroded, it is no wonder that the power in Section 51(1) has been so widely applied. In my opinion, it is a power which, given current judicial tendencies, has the prospect of immense growth in the future, while its limits, whether express or implied, are indeed ever receding. Having now covered the history, scope and limitations of the Section 51, subsection 1, trade and commerce power, I would now like to conclude this episode with one final remark in relation to our Australian Constitution. In Australia, the trade and commerce power has received a wide application, though arguably its case law is far less developed than its American counterpart. The reason for this is really quite simple. Section 51 of the Australian Constitution contains 40 legislative subjects for the Parliament to make laws upon. The US Constitution, by contrast, only declares 18 for the Congress to pass laws upon. As such, subjects such as banking, which is set out in our Constitution at Section 51, subsection 13, is expressly set out in our Constitution under a distinct provision. But in the alternate, in America, that had to be read into their Commerce Clause through judicial interpretations of the Constitution in order to allow the Congress to justify its laws on that subject. Now, the reason our Constitution is so detailed in setting out these subjects is, of course, that our framers had the benefit of hindsight, looking at American history and case law, to determine what should be made express and what should be left for the courts to imply or work with. However, the reason the American provisions were arguably quite limited in their terms originally isn't that they were intended to have a wide application. It's not that the framers expected that the Commerce Clause would be overextended the way it has been. To the contrary, it's probable that they were originally intended to have a much more narrow application. The American framers attempted to create a federal government with a limited source of power and a narrow set of responsibilities, leaving most of the matters which were to arise to state governments to resolve. Nonetheless, over time, the political branches have expanded the powers of the federal government, and the judicial branch has legitimized these growths of power within the federal government. The same process really has occurred in Australia, and this particular head of power evidences such a state of affairs. Now, where once there were limits and distinctions, they have now been blurred or read down to have a much more minimal application in fettering the exercise of government power. This is what we see at the moment with, for example, Section 92. And it is really what we as constitutionalists and principled lawyers should really be seeking to prevent. The erosion of limits and simultaneous expansion of government powers is a sign of growing constitutional obsolescence. It is a defeat of the purpose of this area of law, which is to create limits on the exercise of coercive power. Absent this, of course, absent any limits, a constitution is merely a legalist justification for tyranny, akin to the instrument drafted by Oliver Cromwell, which I mentioned in our Foundations episode, during his short-lived English despotism in the 17th century. If our constitution and our courts don't preserve certain limits on the powers of government, then our constitution doesn't really serve the function which it was intended to serve, which is to not only frame the system of government that we have, but also set the perimeters on what politicians and what the organs of government can and cannot do. Indeed, the reality of the situation is that where a power is needed or where there is some dispute, the Constitution does indeed have an amendment provision in Section 128. If you would like to expand a power or you would like to add a power, it's for the Parliament to propose an amendment and for the people to approve it through a referendum. The courts should not be extending the powers of the Parliament through interpretation or reading down the limits on the existing powers of Parliament by the same process. It's really not good for the future of our constitutional law. Now, with that said, I hope you have enjoyed today's episode on the Commonwealth Trade and Commerce Power, which is the second in our series on the federal legislature. Sticking with some of the main economic powers of the Parliament, on our next episode we'll be covering the corporation's power, which has been widely applied over time by the legislature as its characterization for a variety of laws, ranging from the Corporations Act to regulations of industrial relations and labour laws. From this point, I'm also looking to start producing episodes with guest hosts on emerging constitutional issues, such as reform proposals for a republic, Indigenous recognition within the Constitution, and entrenchment of local government in the Commonwealth Constitution. Please also send me a message on Facebook if there's any particular topic you'd like me to cover, or a guest perhaps you'd like me to invite on to discuss a constitutional topic with. I do hope you'll tune in for our next episode on the Surviving Constitutional Law podcast with your host, me, Cameron Shamsabad. But until then, as always, remember to keep reading. See you next time.